My Lord, for the first petitioner, my name is Ochiel Dudley. It falls on me to take the rejoinder for the first petitioner, and my learned friend, Mr. Masharia, will join me on that duty. And senior counsel will wrap up. My Lord, we are requesting for about an hour if the court can afford it. Yes, for the three of us, the first petitioner's team. Yes.
And my Lord, as indicated before, we still online. Yes,
My Lord, I am still in line too. My Lord, Njeri Maina, I was requesting for only 10 minutes to respond to the issues that Council raised pertaining my character.
We have said that parties who wish to join could file his submissions.
My Lord, I understand that you had given instructions. My colleague, Muge, took the directions that I was to respond specifically on the issues pertaining my character. My Lord, as you can see, the cameras are on. You can imagine the number of people that were watching as I was painted as a sort of warlord before this bench. It is critical, my Lord.
My Lord, that's not an issue that is available to do in a reply. A reply is traditionally on matters of law. Our character or lack of it, it's not really something that will be spoken to. I was also going to suggest, my Lord, we have various priorities. If we could perhaps have a brief lunch break, then people can replenish their sugar levels. Then if necessary, we can have even an extended afternoon, as long as you're sure we close this today.
My Lord, while my senior may not care for his character, I do care for mine.
My Lord, I would plead with this court to take into account that our opponents responded to the petitioner's case orally in court, together with the court of the public opinion. All we are saying is that, yes, let us shorten our respective replies to those responses that were made orally in court. We will shorten, but allow us to do so orally in open court. Thank you.
We'll give you, because we are not obliged to explain to you our circumstances, also, which apparently you don't want to hear or to know about. I'll give you 1.5 hours to respond orally to the responses. And we are not going for a break because we don't have that time.
Thank you, my Lord. My Lord, my name is Ochiel Dudley, and I rise to make a rejoinder. Keeping first things first, my Lord, let me first of all briefly dispense with 3 matters of first principles that came from the submissions by my learned friends, senior counsels Githu Muigai and Mudomi Thiankol. My Lord, let's face it, the suggestion by senior counsel Dr. Thiankolu and Professor Muigai that when you are hearing us on the interlocutory matters, you, with finality, decided the meaning of Article 145 is a suggestion that is repugnant to justice and morality. My Lord, that suggestion that an interlocutory court can determine disputed matters at that stage defies the logic of Uhuru Highway Development versus Central Bank of Kenya, holding that opinions expressed on the merits of a case at the interlocutory stage do not bind the trial court when hearing the matter on the merits. The trial court, I quote, is bound to ignore the findings and to apply its mind afresh to the decision of the issue. My Lord, it doesn't matter whether the suggestions come from the Court of Appeal or the Supreme Court on interlocutory matters, you must apply yourself anew. The other matter of first principle came from Professor Githu Muigai on his ambivalent stand on whether you should intervene or not. At some point he said there's a dilemma. If you intervene, it's bad. If you don't intervene, it's bad. My learned friend, Mr. Gumbo, suggested that you await the voters' help in 2027 in determining whether the Article 145(1) threshold was met, even though it uses legal terms: gross misconduct, serious grounds, and gross violation. My Lord, on that dilemma, there's Cohen versus Virginia declaring it, and I quote again, a treason to the Constitution for a court to decline a jurisdiction it has, much as it is a treason to the Constitution to take a jurisdiction you lack. My Lord, unlike Parliament, a court cannot avoid a decision because it approaches the boundaries of the Constitution, ditto political questions. My Lord, the last matter of first principles that I turn my mind to is Professor Githu's invocation of Mongare versus Attorney General concerning Professor Odek's warning about history. My Lord, when that case was cited, I wonder, why is this case so fundamentally, why does it have such a fundamental principle, but it's so rarely cited? Then I went and checked on Kenya law. Mongare versus Attorney General has been cited 7 times in 12 years. It's a 24th January 2014 case, and obiter dictum responding to the submissions of Nzamba Kitonga Senior Counsel, Professor Odek chooses to say something about the use of historical material in constitutional interpretation. My Lord, a month later, a month after Mongare Court of Appeal, the Supreme Court decided read the matter of Kenya National Commission on Human Rights, and at paragraph 26 of KNCHR, the Supreme Court accepted the same arguments that Odek J in his obiter had rejected in Mongare. And the Supreme Court mainstreamed the use of history as a part of the holistic interpretation of our Constitution. And so, my Lord, you must go back to Bomas, go back to the Kilifi draft, go back to the Wako draft, and see what the debate was about. 9 months after Mongare, in the vetting board case, where the Supreme Court cites Mongare for other reasons, it impliedly again overrules the Odek's warning about history. My Lord, you're told to interpret the Constitution like a will, like a contract, like a mortgage, a document that tells us that I am always speaking. The Constitution is always speaking. You must interpret it in context. You must interpret it purposively. You must interpret it holistically. You must consider the history, the issue about the place of the deputy president, the concern that I told you about in the CKFC for mechanisms that make sure that impeachment does not become a tool for political maneuvering, but remains a sacrosanct constitutional process. My Lord, in the alternative, even if Odek's obiter were the ratio desidendi, this case meets both limbs of the test that he has at paragraph 132. He says that for a court to use the travaux préparatoire, there must be 2 grounds met. 1, the material must be publicly accessible. And 2, the travaux must clearly and indisputably point to a definitive legislative intention. 1, publicly accessible material. 2, that using the travaux would clearly and indisputably resolve the dispute. This case meets both limbs of that test. 1, my former employers, Kenya Law and Katiba Institute, have both ensured that these draft constitutions are publicly accessible. If you go to Kenya Law, if you go to Katiba Institute website, you'll find the Bomas, Gai, and other draft constitutional instruments. Number 2, Looking at those drafts, you'll find that this committee, my lord, it's not about the shall or the may. You're making a constitution. You're not debating verbs, modal verbs, auxiliary verbs. Do we use may or shall? It's about the structures, the processes. You're debating which body should investigate, who should appoint. So that's why at some point it is the speaker to appoint. Then at some point it is the Senate to appoint this committee. It was about who appoints it. Then at some point the National Assembly say the National Assembly will appoint. So when you look at the historical material, as you must, you will find that it resolves that issue. My lord, on the issue of Article 145, there was a landslide of constitutional magnitudes triggered on the 9th of October, 2024. My lord, assume that the option of plenary was there, was available. It was a constitutional choice. It is not. It is not available. But assume it were available. Where is the Senate resolution to investigate this matter by plenary? The motion that was passed, the motion that no one found it in them to second, was for this special committee. That motion fails. My lord, this impeachment, the inchoate impeachment, lapsed at that point. It died at the point of the failure to second the special committee motion. The Speaker does not direct another motion for plenary, assuming plenary were an option available. The Speaker directs that the motion to form the special committee has failed. Pages 48 to 52, Speaker, affidavit of Jeremiah Nyegenye. The Senate says we are going to investigate this, to hear, in fact. It doesn't use the word investigate, which is a constitutional word for that stage. It says we are going to hear this by plenary, like we do for governors. My lord, we agree with Dr. Kamodo that the procedure for governors is different from the procedure for the deputy president. In my opening remarks, I told you that the two articles had been debated differently, so that we agree with him fully that Article 145 comes complete. My learned friend and younger brother, Mr. Mutaidia, suggested to you that there's no difference. My lord, if there were no difference, these makers of the Constitution were legislators, including our team leader, Senior Counsel Paul Mwite, and they sat in plenary at the CKRC. They also sat in committees, in the working groups. They didn't know the difference between plenary and committee, so that they could use, by using the word may, imply that you can read the words plenary into that article. My lord, by refusing to form this special committee, Senate moved this process from Article 145(2), when the motion came in, all the way to Article 145(7). My lord, if you look at Article 145(4), the special committee must investigate the allegations and must do so in 10 days. The Speaker of the Senate collapses those 10 days into two sittings, 16th and 17th, and they are done. So they investigate there, and then they sit over their own investigations. My lord, Article 145(5) requires a hearing. You must be heard during that investigation over the 10 days. That was taken away. Article 145(6) requires a report indicating if or not the allegations have been substantiated. Where is that report before you? That report is not there. 45(6) requires the special committee, not plenary, to indicate if or not the allegations have been substantiated. To report to the Senate is a word the Constitution uses. And my lord, even if the 10 days borrowed from Article 145(3) applied to the plenary sitting, the Speaker and senators denied the Deputy President the balance of the benefit of those 10 days. My lord, Dr. Thiankolu told you about the parade of horribles. the fear of constitutional processes without timelines. My Lord, Article 259(8) of the Constitution tells us that where no specific time is provided, then you need to perform the function without unreasonable delay. And Rule 12 says that after the committee reports, my Lord, and Senate is now hearing the Deputy President at the second hearing. That article has 2 hearings. 145(4) he's heard in investigations for 10 days. 145(6) is heard on his defense to the charges that have been substantiated. 2 hearings. Now, the point I was making is that, yes, about Rule 12. My Lord, Rule 12 says that the second stage hearing, the hearing will be held from day to day until the Senate votes on the matter. My Lord, that's language you are familiar with. The court has heard us from day to day until the conclusion of this matter today. So the parade of horribles is really, my Lord, nowhere. And my Lord, because of that cascading failure, the failure to form a crucial committee that we can see in all constitutional drafts, that we can see in all democratic countries, the inquiry panel, you being addressed on Falafala, but they don't have to tell you about that there's a mandatory inquiry panel in South Africa that also investigates, the House Judiciary Committee that also investigates in the US. My Lord, not to rehash my arguments, and also coming to Onyango law, the respondents have tried to. My Lord, I've already noted what the court wants me to do, and I'll do it. My Lord, my respondents could not distinguish Onyango law. If Onyango law was about unfair hearing, so is this case. And on the Duterte case, which was cited to you by everyone, my Lord, all 13 judges in Duterte take up jurisdiction and nullify the impeachment. But Duterte is cited to you as saying that he should not take jurisdiction, that it's a political case. My Lord, if you look at the lead judgment of Leonen, he says that it's a legal, political, and constitutional procedure. It is not purely political. It must comply with the Constitution. And that, obviously, sham complaints must be dismissed immediately. These involved sham complaints that needed to be dismissed immediately. My Lord, the decision that is cited to you is the decision of Hernando J., one of the judges who write separate opinions, and it is his obiter dictum. His ratio decidendi concurs with the majority that the court not only has jurisdiction, but that impeachment is also a legal process. My Lord, what they cite to you as the court's decision is the court's framing of issues. The court is saying, here in this case, you have challenged how this was done. We will not tell Senate how to handle the merits. We will not speak about the merits. It was not the ratio of Hernando J. in the Duterte case. My Lord, the jurisprudential gods must be crazy. On 8th of May 2026, while my learned friend, Professor Githumigai, took the podium to tell you that you should shirk jurisdiction, the EFF court was delivering its decision asserting jurisdiction, both over the process and over the vote of the National Assembly. That's precisely what you're told not to do. You're told don't substitute your judgment over the vote, majoritarian vote of Parliament. Well, that decision, you won't believe it, at paragraph 49, also interpreted the word may, Maya Chief Justice, in the EFF case, the Falafala judgment. And she says, I quote, that may does not always imply the existence of a discretion. My Lord, Maya also says at paragraph 38 that the Constitution itself requires judicial intervention by the court. My Lord, 3 months before Maya, the Lesotho case that has been cited to you, also took up jurisdiction over Parliament and directed Parliament to enact the legislation. And my lord, how ironical the law is sometimes. The word may also came up in that decision. The word that you're now being told means discretion in all cases, even if interpreting it as discretionary leads to absurdities of untold proportions. In that case, the Lesotho case, Mojapela case, my lord, the court held that although may generally connotes discretion, you must look at its purpose. Remember here you're being told that the Constitution is a dead letter law. Don't look at its intention. Don't look at its purpose. Interpret it like a mortgage. My lord, my learned friend, Dr. Thiankolu, took the stand and told you that no country has ever interpreted may to mean shall. He cited Australia. And I wondered if he'd looked at our further bundle of authorities. We have a case from Australia saying the same thing that our court has also said, that whether may is permissive or mandatory depends on the context. My lord, we've cited to you in our further bundle the case of Sony Holdings versus Registrar of Trademarks, Court of Appeal, 2015, Kenya law, National Assembly versus Okoiti, Court of Appeal, 2024, Kenya law, Peter Muturi Njuguna versus Kenya Wildlife Service, 2017, Court of Appeal, Mayor Agri-Traders versus EcoBank Kenya Limited, Court of Appeal, 2020. In short, we've cited to you purely Court of Appeal decisions, saying that whether may is discretionary or mandatory depends on the context. My lord, so look at Article 145, make the may discretionary, and look at the cascading failure. Look at Article 145, 3B, make the may as mandatory. A committee must investigate these charges and look at the effect. My lord, that article is simply sequential. National Assembly cites to you the authority of Helen Santhaki, saying that the semicolon coordinates related sentences which belong together, yet are slightly separate. There is not only a semicolon, but also an and. So that authority cited by the National Assembly applies even with greater force here. My lord, that article just says that after you've done 145 3A, do the 145 3B, the and. Professor Ojenda did not even mention that article once in his submission. My lord, allow me to move to another issue, and that is the issue of, in order to accept the respondent's submissions, you must, using the pens you now have, my lord, pick up Article 145, and wherever it says special committee, you must add the words or in plenary. So when it says the Senate the Senate by resolution may appoint a committee of 11, you must say or plenary. May appoint the House in plenary or the special committee. When it says the special committee shall investigate, you must add there, my lord, or the House in plenary, the committee or the House in plenary. When it says the special committee shall hear the deputy president during the investigations for 10 days, you must say the House in plenary or the special committee of 11. My lord, Professor Ojenda substituted that special committee of 11 with the House sitting in plenary as 68 members. My lord, there is a may in Article 168(8) of the Constitution, and this is to show that it depends on context. Professor Dr. Thiankolu, my lord, maybe that's a prophecy, suggested that, if you interpret the Article 145 may as discretionary, then you must do that in every case where the may appears. There's a may in Article 168(8), my lord. That may says that a judge aggrieved may appeal the tribunal's decision to the Supreme Court of Kenya. My lord, we'd laugh out of town would take a moment to laugh if anyone suggested that because that may is there, it is discretionary. And a judge aggrieved by the removal, the tribunal's decision to remove them, can come to the High Court, can go to the ELRC, can go to the Court of Appeal. Why not? Yes, there's a may there. My Lord, may in law is not always discretionary. Our high school grammar teachers told us, yes, it's discretionary. But my Lord, they were not teaching us legal language or interpretation. There's another may in Article 163(6) of the Constitution. Now that may is discretionary. It's about the jurisdiction of the Supreme Court. My Lord, the case from Lesotho told us that may can confer a discretion or can confer a duty and a power. So the Supreme Court has discretion to give advisory opinions under the may in Article 163(6). But it has a duty and a power under Article 168(8) to hear judges aggrieved by the decision to remove them. My Lord, my last issue is this one, and this is about the drafting history of Article 145(3)(b) and the way it conclusively addresses this dispute. My Lord, earlier drafts of Article 145(3)(b) used a conditional if. They said if a motion passes, the motion comes, then senators hear it. Dr. Kamodo told you that they have discretion. They must not always impeach. They hear the motion. They find that it's a blue shoes motion. They vote the motion down, like the one that died on 9th October 2024. The impeachment should have died there. They don't have to appoint the special committee. Why? Because they've exercised the political power you are told they wield to defeat the impeachment motion. It wasn't intended that every impeachment must run all the way to the end and result in an impeachment. Remember, there's 145(1) that has threshold. The senators look at the threshold. They say there's nothing here. Wearing a blue coat is not an impeachable offense. So this motion, we are defeating it. My Lord, earlier drafts, before the politicians came in, used if the motion passes, and then it said the speaker shall. So they're trying to change, okay, speaker alone, you can't do that. Let's bring it to the Senate. So the next draft says, if the motion passes, the Senate shall. About 3 drafts said that. We've given them to you. And then, my Lord, after the failed referendum, negotiations are going on. Again, it's in our further bundle. The language then changes and begins to say, upon hearing the charges. At the end of that, the National Assembly took up this role, and they harmonized. The Committee of Experts brings it back to the Senate, and then it comes back with the May, which is there, my Lord. My Lord, just to conclude, looking at that draft, it is clear that the May refers to the passage of the motion. If the motion passes, the Senate must then appoint the special committee. My Lord, I close with the relevance of gubernatorial cases, and I rely on the submissions by Dr. Kamodo on that those two processes are entirely different. At any rate, in Sonko, this court warned about the potential for a plenary investigation to be fused into a mash that becomes a lynching mob. And no one told you about the Senate digest. No, none of them, not my friend Mukele Moni, not Ms. Thanji, not Professor Ojenda. The Senate, in its digest, which we placed on record, recognizes this warning. My Lord, this petition leads to an inevitable outcome, and it's being allowed, my Lord. My Lord, allow me to close by a quote by Shakespeare, that looking at all these, what has happened here, the substantive, the procedural violations, Rigathi Gachagua was a man more sinned against than sinning, like King Lear in Shakespeare. My Lord, may I request you to invite my learned friend, Mr. Masharia.